Hello friends, Namaskaram. How are you? Myself is Dr. Jinesh Soni. I am an advocate. Har Har Mahadev Jai Shiv Shambhu. With the blessings of Almighty, we are going to discuss an important topic concerning a check case. In a check case, you might be acquitted, you might be convicted, but it depends upon the facts and circumstances. But in case there is a compromise and you are acquitted, but despite of that you are facing the legal trouble, how it's possible? So concerning the same, we are discussing entire thing in the present class. I request all of you to maintain a proper notebook with pen or pencil so that how to deal with the issue I could enlighten you. So basically, we have to note down the problem. There is a person named as Mr. A. He is having a case against him as per section 138 of NI Act. The court summoned him, but he failed to appear. Despite of warrants, he failed to appear. Finally, he has been declared proclaimed offender. In the meanwhile, there was a compromise. Finally, compromise has been executed and he has been acquitted by the consent court based on compromise. One of the fine day, he got proceedings acquittance that a case of proclaimed offender as per section 174A of IPC is pending. He got panic. So what Mr. A can do? I think that in all over India, we might have such trouble. So basically, if it is a trouble, there is no need to worry. There is no need to go for a bail, for the trial. Simply, we have to follow certain steps by the virtue of which we could easily go for quashing and could be acquitted from the charges of section 174A of IPC. So basically, we are having the problem. Now, I am coming on solution. As far as the proceeding of section 174A of IPC is concerned, in nowadays, it corresponds to section 209 of BNS. So whenever there's a compromise, we have to write a proper compromise deed as per section 147 of NI Act. In the compromise deed, we have to mention the 5 important facts. Number 1, the compromise has been occurred with free will without any undue influence. Number 2, the entire amount of check, we have to specify the details of check as well. In addition to this, do not pay any compromise amount by the way of cash. Pay only in accounts of the concerned complainant. Number 3, also specify that it includes the litigation charges, advocate fee as well. Otherwise, you may face the consequences of section 400 of BNSS. Number 4, you have to specify that after acquittal, no proceeding in nature of proclaimed offender will be initiated, and in case it is initiated, the concerned complainant will cooperate to withdraw the same, to dispose of the same, so that the rights of concerned accused could not be prejudiced. And number 5, we have to mention that every fact we have mentioned are true, correct, and nothing is concealed. And in case it is found that certain material facts are concealed by the complainant resulted in the perjury despite of compromise, in that scenario, the accused will be free to initiate proceeding against the complainant. In this way, we could minimize the chance of being cheated. So, in check cases, drafting is important. In a simple way, if we submit our compromise deed and in future the panic occurs, do you think that complainant will come to help you? We have to bind the concerned complainant. Otherwise, we have to face the consequences in isolation. So we have to draft the compromise deed as per section 147 of NI Act so that we could bind the concerned complainant as per section 15, section 121 of BSA. After the settlement of matter, means you are acquitted by the concerned trial court concerning offences of section 138 of NI Act. Obtain the certified copy of entire file. File means the complaint, the order sheets, the compromise deed, the affidavit in support of compromise deed, if any, and the order of consent court, by the virtue of which the compromise deed has been accepted. Because sometime we ignore the said step, and in case in near future there is a proceeding against you in nature of proclaimed offender. At that spur of moment, we have to go for questioning. But regarding questioning, we need all these documents. This costs panic to you, and in the emergency, you have to pay the exorbitant charges. And to avoid a sad scenario, we have to work from the inception. In case you find that there is a proceeding against you in nature of proclaimed offender, despite of getting worried or panic, please move as per section 5 to 8 of BNSS. We have to submit to the concerned High Court that the proceeding is liable to be quashed because the main case is quashed on the basis of compromise. So the consequential proceedings could not be allowed to be continued, and their continues would be nothing but abuse of process. And I'm going to specify you three important judgments of Honorable Punjab and Haryana High Court. Mohammad Hanif versus State of Haryana, Balde versus State of Haryana, Ashok versus State of Haryana. In all these cases, it is specified that if there is a check case, ultimately compromise has been occurred. And finally, nothing is pending. Based on compromise, the accused has been acquitted. In that scenario, the consequential proceedings of Section 174 of IPC could not be sustained. It is liable to be set aside and quashed. And recently, we are having the judgment of Honorable Punjab and Haryana High Court, dated 8th of Jan 2026. Even in that case, it is specified that if there is compromise in the check case, the accused has been acquitted based on compromise, the consequential proceedings of Section 174 of IPC could not be allowed to continue. It is liable to be quashed and set aside. So in that way, we could obtain the remedy. So I specify you what to do and how to proceed concerning the compromise if occur between you and the concerned complainant concerning the check cases, so that if there is any trouble of proclaimed offender, we could easily encounter the same without any worry, without any panic. See you in the next video. Till then, Har Har Mahadev, Jai Shiv Shambhu.